Or good morning or good afternoon, rather. I'm sorry.
Good afternoon. This case is being live streamed on YouTube. It is a dependency case, and I don't think that we're going to have much occasion to get into the specific substantive facts of the case, but let's be mindful that we refer to the appellant and her child by their initials if we refer to them at all. Um, I'm Dan Traver. I am the Chief Judge of this court, and I'll be presiding today. I'm joined by my colleagues, the Honorable Jared Smith and the Honorable Roger Ganham. We're here today on our December 12th, 2025 order, which directed you to show cause why sanctions shouldn't be imposed against you personally for failure to comply with our October 25, 24 and November 2025 orders. And I want to give you an opportunity to respond today to that show cause order. But before we do, I'd like to set some background that shapes what we'll be talking about during this hearing. You were appointed to represent the appellant in this case in May of 2025, it appears, although there was an amended order that was entered in August of 25. Looks like there's a two-day trial that occurred in July of 25. The trial court took the matter under advisement. It issued a final termination of parental rights judgment in August of 25, and it's on September 10th of 25, you filed a notice of appeal. Um, the same day that you filed a notice of appeal, we issued three orders. One recognized that this is, like all termination of parental rights cases, an expedited proceeding. One advised you of the process for withdrawing. Another advised of the process and obligations to prepare transcripts and records. Um, on September 18th of last year, the trial court filed the record, and the rule, as well as our order, requires that appellant file an initial brief within 30 days of the record being transmitted. So when that did not happen on October 24th of last year, we directed you to file an initial brief within 10 days or face dismissal of the case and or sanctions. There was no initial brief that's been filed in the case. On November 20th, we ordered you to show cause why sanctions should not be imposed against you for failing to comply with our October 24th order. You did not respond to that order. On December 12th, we set this matter for hearing today. We offered you the chance to show cause in writing why the hearing should not take place, or why the show cause should be discharged, or why sanctions should not be imposed against you, and no written response has been filed. So with all of that said, Mr. Wells, how would you like to address the actions or lack of actions in this case so far?
I, in preparation for this hearing and going back to my notes and looking through my emails and the like, I mean, in short, I was the attorney of record and therefore am the responsible party, if you will, here. There's no question about that. The failure was mine. However, as the court indicated, I was originally court appointed to represent KS in the underlying determination hearing or trial rather. I did that. I am not on the court appointed list to do appeals. Initially, KS indicated to me that she did not want me to file a notice of appeal, that she was going to hire counsel to do that. So I waited a while before I did anything. Ultimately, through continued conversation with KS, she advised that she would want me to file the notice, but that she would be hiring private counsel. So I filed the notice. And once I received the October 24th order, we reached back out to KS to advise, sort of what the status of the case was, that nothing had been done yet. We were assured by KS that she had just hired or was in the process of hiring appellate counsel to do this, and again indicated she did not want me, nor did she want court-appointed counsel. That is where I think I made sort of, I don't want to over dramatize this, but sort of the ultimate sin. I made an assumption, and my parents taught me better than that. I know better than to make assumptions, but I made an assumption at that point that she had, in fact, followed through and got private counsel, that they would be filing some information as far as the notice goes, and likely, I would imagine, a motion for an extension. Um, I did not, and I went back through all of my emails. I checked all of my folders. I've gone into junk mail and the others. And I cannot find in my emails any November 20th order from this court. Now, I'm certainly not suggesting this court didn't send it to me. That's not what I'm suggesting at all. Just advising that I didn't see one, I didn't have one. The next communication I received was the communications about the sanctions hearings. In retrospect, I should have very simply filed a motion to withdraw at the time that I filed my notice of appeal. I've not done a TPR appeal before. I have done criminal appeals before, and I have at times had lawyers file a notice of appearance once they were advised that they were in, and it sort of just does the transfer. That's been many years, I will admit as well. But at the end of the day, Your Honor, I understand that I am the lawyer who filed the notice of appeal, and therefore I've got some responsibilities and obligations. And I did not, candidly, I did not satisfy those in the professional manner in which I should have. I made an assumption at one point, which again I understand is leading to issues and problems. But I had been communicated with KS on multiple occasions who advised that she did not want court-appointed counsel, she did not want me, and that she had in fact hired private counsel to perfect her appeal. I relied on that. I should not have, in and of itself, relied on that. I should have taken steps to withdraw myself from this matter. Um, and I did not do that. And for that, I apologize to the court, and am here to, accept, the sanctions, if any, that are deemed appropriate.
How long have you been practicing, Mr. Wells?
I was admitted in 1995.
Do you have any type of a disciplinary history?
Um, Nothing current. I have been disciplined by the bar before in the past, probably back in 2000, um, and maybe once in 2010.
What were those for?
One was with the result of a 3850 that I had perfected with the court, and the complaint, if you will, was essentially this woman was in custody and didn't feel she'd had adequate contact with me. Um, the other one, I believe, had to do with I received a I received a check that I put into my trust account. Actually, I cashed it through my trust account, and the check ultimately did not clear. And that was the initial process of the complaint. Um, and at that time, I was asked to reattend trust accounting classes and the like, and that was essentially it. Um, those were the two findings.
Your Florida bar profile indicates that you do criminal appellate work. But do I understand what you said correctly, that you don't do dependency appellate work?
I've never done dependency appellate work. I'm not on the court appointed list for dependency appellate work or any appellate work at that matter. And frankly, I haven't done criminal appeals in several years. I sort of don't do those anymore. I probably need to update that on my Florida bar, but I just don't anymore.
Are you mindful of the Florida Rule of Appellate Procedure that controls family or dependency appeals and the obligations that rule places on trial counsel as distinct from appellate counsel?
To be candid, I am not, because I've never done dependency work. I've never had a dependency case ask for an appeal to be done. This was the first time. Again, I'm not suggesting that that's an excuse. Please understand, I'm not trying to make excuses here. But no, sir, I'm not familiar with dependency appellate law at all.
And how many dependency cases have you handled in your trial capacity?
I have done probably two dependency trials, and this was, I believe, the first TPR trial that I actually had that going to through the trial.
Were you appointed to this trial as privately retained counsel or as part of, like, in Orange County, we called them conflict wheel counsel, where there was not RCC or you see it in the criminal realm, the PD ability to handle it.
Yes, sir. I was appointed through that same kind of process. It was a contract. It was after RCC withdrew due to representing the father. Criminal, well, not criminal, but private lawyers are then on a rotation list, and I was appointed through that.
How long have you been on that wheel for dependency?
Maybe 4 or 5 years at this point.
Okay. Um, what steps have you taken since you received any of our orders to withdraw or to ensure that your client's interests are protected in this appeal?
The only steps that I took again, and the first step was contacting the client back in October and advising, if in fact she had followed through and hired this attorney that she had indicated she was going to hire. At that time, she advised that she was. And since I was aware of this sanctions hearing, my office did prepare a motion to withdraw, and frankly, we included in that motion a request that a public defender be appointed to perfect the appeal. That has not been heard yet. It was very recently drafted. I was out for most of the holiday period, and once I returned and saw these emails and the like, and talked with Miss um, Pectoral, I guess, Pectoral. Yes, that was when
You're referring to our clerk of court, Stacy Pechtel?
yes, sir. She contacted my office, and when we spoke, and at that point, I did file a motion. Again, I don't believe it's been heard yet. It's somewhere in the 10th Judicial Circuit, and I intended to follow up with that tomorrow to find out from the court if they've in fact received it, and if they need to have a hearing or if they're just going to grant it.
Okay, and you anticipated my next question, which is that you've not followed up, having filed that motion to
Not as of yet, no,
try to
sir.
get it prioritized. Okay.
No, sir. I will be in dependency court tomorrow morning and intended to, in fact, in front of the same division and intended to inquire at that time.
Um, in looking at the record on this case, it appears that you're in the wake of the trial court's TPR judgment. Your client attempted to fire you and self-represent, and the trial court made a determination that because of her, as the trial court described it, her mental health issues, she didn't have the capacity to make that choice. Is that correct, sir?
That is correct. And that is something that, again, in retrospect, should have been more than enough for me to decide at that moment not to rely, quite frankly, on KS's representations to me about hiring counsel. And when I filed the notice of appearance, I should have also included in that moment a motion to withdraw and ask that appointed counsel be appointed. If she ultimately hired somebody later, they could have substituted in. If she didn't, at least she would have been represented. That would have been the appropriate thing for me to do. And I didn't, and I didn't in part because I was relying on her representations, which it was a strange matter in the sense that she wasn't incompetent, but she had some mental health, and it was different for me. I'll put it that way. It was just a different situation to be in. Um, Having a client that I've consulted with, that I've tried to assist with, that I've had communications with, but at the same time knowing there were levels of mental health factors at play. Um, and so yes, and again, I'm certainly not trying to blame her. I'm not at all trying to displace blame and responsibility, but it was a different sort of situation. I even felt during the trial that it was again, it was just strange. I wasn't sure if because of the mental health that was clear that even the advice I was providing was getting through. It was just strange for me. In the 30 years I've done this, I've never really been in a situation like that. I've had clients that were incompetent, and those are sort of easy to deal with. We know that process, but I don't know that I've actually had a client who had the mental health levels that she had, but was still competent to proceed. And so yeah, trying to figure out how much of her wishes do I take into full account and try to act on, and how much do I step aside and say professionally, sort of put myself in the shoes maybe of a mental health person. Do I take this? Do I hear this? Do I act on this? Or do I do the lawyer thing and sort of maybe sometimes disregard my client's wishes?
You've acknowledged that you're not mindful of the rules, so I'll advise you that 9.146H directs us to prioritize dependency cases and termination of parental rights cases. Do you appreciate why we're directed by the Florida Supreme Court to prioritize these cases?
I do. I believe it's similar to the same reason the trial court levels are directed to prioritize them. Yes, sir.
And the 9.146 places some obligations on the part of the trial lawyer to assist in the expeditious preparation of the record and transcripts. I'll note for you that no transcripts have been filed in this case yet. Have you done anything to prepare for that, to ensure that they've been prepared or that they're going to be able to get filed?
To be candid again, Your Honor, I have not.
So I think that you'd agree with me, even if you were going to prepare this appeal, that you couldn't file an initial brief challenging anything that the trial court might have done at trial without the trial transcripts, correct?
Agreed.
So you understand that because of this conduct, we are not going to be able to prioritize this case in the manner that we normally would be able to, because we're going to have to oversee the process of getting successor counsel put into place, get the transcripts, and then somewhere down the line, evaluate the case substantively.
That's correct, Your Honor.
Judge Smith, do you have any questions for Mr. Wells?
Well, I guess, Mr. Wells, I appreciate your taking responsibility. I do want to say that up front. I had a couple questions. I guess one is just pretty factual here. When your client told you that she had hired counsel, did she ever give you a name of the attorney?
She did not. She didn't really want to get into that with me. She was very, especially after the court denied her request to self-represent or to do something else. Our communications were somewhat evasive, I suppose. When I communicated with her, she's seemed very suspicious of anything related to the court-appointed counsels, the judges, the procedures, and so she was um, not very willing to share specifics with me.
Okay. Did that raise any flags to you that she wasn't telling you the name of the attorney? Like maybe she's just misleading you a little bit and not telling
It
you the
didn't
full
raise the
story?
flag of being misled, honestly, because she has moments where she could be very, I don't want to say convincing, but very reasonable sounding, I suppose. And despite the findings of the mental health challenges that she has, um, and it was consistent with other events that I've had with her where she was less than forthcoming with information, but what the general information she provided ultimately did come to pass with regard to witnesses and the like. Um, it should have been, as I indicated, it should have been a red flag to me, and I should not have assumed, which I did do, quite frankly, that I could take it at face value. Um, and that again, it's entirely my fault and my poor judgment.
Okay. You checking the docket on this? I mean, from the time you filed the notice of appeal back in September, were you watching to see what documents were being filed?
I received a few notices that the record had been prepared, and then after I believe the October 24th, there was a check by my office to see what the status was, what the docket entries were. Um, but again, candidly, I did not do really any checking after that. I took it that she was hiring counsel and that counsel would sort of step in. Again, bad decision on my part, made assumptions on my part. Um, but I will say, even though I haven't gone through the process of doing a TPR appeal, the process is slightly different than in criminal court. And that is, I guess, where I've got at least a little bit of experience. And I think inherently in my mind, made another assumption that maybe there were some similarities there. And so I didn't take the extra effort to see that there were differences and that there were different timetables and the like, and things had to be done a little differently.
And again, I appreciate you recognizing that you made a mistake here.
Yeah, absolutely.
It goes a long way, frankly, with me when people admit that. Um, would you concede that because you've admitted doing something that you know is in violation of our rules and in violation of our court order, that we have to do something in response to this?
Absolutely.
Okay.
Absolutely.
Have you thought about that? When you walked in here today, did you think, this is what I believe would be a reasonable sanction from the 6th DCA?
Honestly, I think the best way I can answer that is I came into this frankly expecting a sanction, but I'm not sure what appellate sanctions generally come about. So I wasn't sure what's the parameters of sanctions and therefore what would be potentially appropriate or not. Um, I I expected maybe a financial sanction, I suppose, but beyond that, I'm just not sure. As I indicated, I certainly can appreciate maybe wanting me to take a course or take some CLE classes with regard to this, but then I thought I'm not sure because I don't ever intend to do dependency appeals. I just don't. I specifically do not put that on my contract when I seek to be on the contract list for Polk County. I just don't want to do them. And so, although I would certainly abide by whatever this court advised I needed to do by way of a sanction, I don't know that that sanction would facilitate avoiding this error in the future, as I don't intend to be an appellate lawyer in dependency court.
Okay, that's all I have. Thank you, Mr. Wells.
Judge Ganham.
Mr. Wells, you mentioned that you, upon receiving our October 24th order, you spoke with your client. I just wanted to confirm that in that conversation, and without disclosing, of course, anything that's privileged, did you communicate to KS our caution that failure to file a brief could result in dismissal of the appeal without further notice?
I did advise that action would need to be taken, yes, and that she needed to let her lawyer know of the status and that I'd received communication from the court that the clock was ticking and things needed to be done very quickly at the risk of potentially having her appeal dismissed. And I asked her specifically if she did not intend to appeal that decision. If she wanted to let me know that, I would then file something with the court asking for a voluntary dismissal. She advised that no, she's got a lawyer and they're going to go forward.
Okay, thank you.
Mr. Wells, is there anything else that you'd like to say before we adjourn?
The only thing I'd like to say is, and I have reached out and as well to KS to advise this. I apologize to the court. This was beyond my sort of experience here. That's no excuse, as I've indicated. I've never had this situation come up before, so even though I've been practicing a long time, this has just never been a place I've been, and I should have been more mindful and, quite frankly, more informed for myself as to what was required. I have certainly made notes going forward. I'm still on the dependency list, and will ensure in future times that when I file notices of appeal, should that come up, that I take additional steps to withdraw, to get out right away. And if there's any delay or if there's any discussion with my clients about whether or not they're going to seek court-appointed counsel or private counsel, I will likely withdraw with the request that court-appointed counsel be appointed so that there is at least an attorney there. And if the client does, in fact, ultimately hire private counsel, then they could do substitutions or whatever they want to do. But I've made a note that going forward, there's a new process in my office about how we handle these, and we're going to do what we can to avoid anything like this from happening again. Apologize to this court. I apologize to my client. I apologize to the process. This was entirely my fault. I am the attorney who was responsible for this, and I did not meet the level of professionalism and appropriateness that I should have.
All right, we will take the matter under advisement and we'll be adjourned.